We'll now call case number 116515, State of Kansas versus Christopher M. Harris.
May it please the Court and Counsel, Assistant District Attorney Matt Maloney for the State. And, Your Honor, I'd like to request 3 minutes of rebuttal.
3 minutes is granted.
Thank you, Your Honor. As a brief factual summary, the defendant was on parole when he got into an argument with another gentleman, and during that argument he pulled out a pocket knife and threatened to cut the other man. As a result of that encounter, he was charged with multiple crimes. As relevant to today's appeal, one of those crimes was criminal possession of a weapon by a convicted felon. Before trial, the state filed a motion in limine seeking to exclude evidence that the defendant's parole officer had told him that he was permitted to carry that pocket knife, and to similar information that was contained in a DOC handbook that the defendant had received. The court granted the state's motion in limine and excluded that evidence. The defendant went to trial. He was ultimately convicted of just that charge, the criminal possession of a weapon count. And on appeal, the Court of Appeals reversed on that issue, determining that the court should have allowed that evidence to come in as a mistake of law defense. The Court of Appeals ruled in the state's favor on a second argument raised by the defendant, which is whether the statute was unconstitutionally vague with respect to how it defines the term knife. With the court's permission, I plan to start with the issue that the panel reversed on, which has to do with whether the court erred in excluding that evidence and granting our motion in limine. As an evidentiary issue, whether the evidence was probative is reviewed for an abuse of discretion, whether it's material is de novo, and to the extent that the issue requires this court to interpret statutes, of course, it is also unlimited review. Now, a mistake of law defense requires that mistake of law negate the culpable mental state. And KSA 21-5207B4 applies if a defendant has acted in reliance upon an official interpretation of a statute made by a public officer or agency legally authorized to interpret the statute. Our position, quite simply, is that the defendant's parole officer was not legally authorized to interpret statutes. As I set forth in the brief and in the supplemental briefing and petition for review, there is a statute, 75-5216, that expressly sets out the duties of parole officers.
Is it really about that, though, or is she not just really parroting back the handbook that comes from the department? So then we would look at whatever authority and responsibility the department has to work for the reentry of people who have served their sentence and their reentry into the community.
Right, and I think that clearly does play a role. That the handbook clearly, as you pointed out, as something that's produced by the DOC. And what the Court of Appeals did here is they looked to KSA 75-5201, which sets forth the duties, the purpose of the DOC. And that seems to be the statute that the panel thought creates this authority to interpret statutes. Our position is that conclusion was an error. And I've cited, in my supplemental brief and petition, I've cited that statute there. And what that statute says is that it's the intent of the legislature that the Secretary of Corrections or his or her employees or agents will construe and apply this act to rehabilitate, train, treat, educate, and prepare persons convicted of a felony for entry or re-entry into the social and economic system. Again, lacking from that statute is any reference to statutory interpretation.
It's not really statutory in so much of, I mean, it's not like statutory interpretation like the Attorney General gets to interpret anything that comes, all the books. But it seems like that provision, like the Court of Appeals said, truly does talk about and would require the department to know what people on probation or on parole can do and not do in order to avoid getting thrown back into jail.
Well, I think it does with respect to what their conditions of parole or post-release supervision are. And I think that's where, to me, the Court of Appeals opinion seems to almost equate and treat as one and the same conditions of post-release or parole and general statutory interpretation or just somebody's general obligation to follow Kansas criminal law. Clearly, everybody, whether they're on parole or post-release or not, is subject to following the laws of the state of Kansas.
But for the parolee or the post-release supervision person, they're told specifically that's one of your conditions of being on release, right?
I think the handbook would indicate, that you have to follow the law, and in addition to these other...
And in this case, it gave a specific explanation of how you follow this particular law, which is one that would reasonably come up a lot with people that have just gotten out of prison. Can you have a knife?
Right. Well, I think there are two things there. The handbook itself certainly doesn't... The handbook does not ever cite any particular statute. Obviously, there are dozens, if not hundreds, of criminal statutes in Kansas defining crimes. And this 12 or 14-page handbook does not reference a single one of them, let alone this specific statute.
Which probably speaks to its readability.
Sure.
Because, we'd probably do a lot better if we had fewer citations to statutes and the things that we deal with. I'm serious.
No, I
You're
agree
trying
completely.
to communicate to a certain population. So why does it matter whether they're citing a statute and saying this is why you can or can't have a 4-inch knife, which is what the handbook said, as opposed to you just can't do this?
Well, I think it matters because the mistake of law defense specifically ties this to he has to have been acting on reliance of an official interpretation of a statute. So if that's
That doesn't mean he needs to know it was this official interpretation of a statute, doesn't it? Just he needs to know what he was told.
Well, I would argue that it does mean that. If it specifically says that it has to be an official interpretation of a statute, I think that's... Otherwise, somebody could just rely on essentially anything that they're told and say, well, somebody told me this, and therefore I relied on it.
Don't you want this person's...
Sorry,
go ahead.
Need to know it came from someone to him is an official who has authority over him.
Right.
I agree with you on that. I'm not just talking about somebody wandering by on the street or reading a Facebook post or whatever. But he doesn't need to know that the person who was speaking to him had gotten a statute book and read it and interpreted it. He just needs to know the person talking to him is somebody in a position of legal authority, and this is what they say the law is. You can have a knife that's so big.
And even assuming that that's true, our position is that this person is not authorized to do that.
I know that.
You mean the agency?
The agency and the specific parole. Yeah, but both the agency and the specific person. Again, we have these statutes that set forth both the specific duties of parole officers and then the purpose of the agency itself.
Who do we want this person to get their understanding of the law from, if not the parole officer?
We want them to get the understanding of their terms of the specific terms of post-release and parole from their parole officers. But as far as their general understanding of the law, I don't think that they're any different than you or I. As somebody who's not on parole, it's my obligation. I don't have somebody telling me, basically interpreting statutes for me. It's my responsibility, and I would argue it's the same for this person, to know whether, mistake of law generally is not a defense.
Are parole officers empowered to make all kinds of judgments regarding the law when it comes to violations of parole conditions. And if they're not authorized to kind of set conditions, who is? Don't parole officers interpret the law all the time and affect arrest warrants and actually I think have arrest powers?
They certainly can issue warrants, and I would agree that they should be able to make determinations as far as whether somebody has violated. For instance, if as a term of post-release or parole, somebody is required to, whatever restriction you might choose, live inside the state of Kansas or seek employment or be subject to random UAs, stuff that those of us who aren't on release are not subject to, then I think clearly parole officers are, and I think the statutes do give them power to do that. As far as whether they ultimately are interpreting statutes or making decisions of the law, while they can issue arrest warrants, ultimately, obviously, it's up to a court to make the determination of whether that's valid. A parole officer could issue a warrant because they think that somebody has violated the law of the state of Kansas. If their interpretation of that is wrong, then clearly the court will not find that person to have violated the law. As I point out in the brief, I think that in addition to our primary argument, which is that the statutes simply don't give the agency or parole officers the power to interpret statutes, I think there's a public policy argument to be made as well, which is a backup argument, but I think it's a valid one. These people are not, it has nothing to do with their intelligence, it's just simply that they're not trained specifically in the law. These are not people that have to have law degrees. It's, as we all know, as people who work in the appellate world, those of us with law degrees and lots of experience doing this have difficulty interpreting statutes.
Let me interrupt you and ask you on that point about the statute itself. And I believe is it 6304C1, the definition of the weapon at issue here?
Right.
Would this person have been prohibited from possessing a pair of scissors under that statute?
So I guess transitioning to the first issue, the
issues seem to me to be pretty closely intertwined.
I think that so with respect to the first issue, I guess with respect to scissors, it's so hard when there are so many different hypotheticals, and I think
isn't that exactly the point?
Well, it is in a way that it serves to illustrate the primary argument that I raised in our brief, which the Court of Appeals seemed to not specifically address. Below, at the district court, the defendant's argument on that issue was solely confined to hypotheticals that were not his facts. He made the arguments with respect to plastic butter knives and other things like that. That's the exact type of argument that you're not allowed to raise when you're arguing the statute is void for vagueness. You cannot argue that it would potentially be unconstitutional applied to other facts. He's not entitled to now, on appeal, shift and try and focus on the specifics of this case with respect to a pocket knife. So our position is that any arguments with respect to hypotheticals are not properly raised in this particular case. If he had had scissors or a plastic butter knife, then we would be properly talking about that. But as somebody who had a pocket knife that in the state's opinion clearly fits within this because it is a sharp, an object with a sharp edge or raised or blade that would clearly constitute a cutting instrument. That's why I think that we're not supposed to go down that route of looking at every possibility. Well, how sharp are the scissors?
Can I construe your lengthy answer to my question as I don't know?
Right, yeah, that's fair. And I think that's exactly the point. That's why we shouldn't be doing that. There are infinite possibilities of objects, and I'm clearly...
And if you, as a trained lawyer, as you recited, somebody who is educated and schooled, and this is your profession to understand the law, you cannot answer the question.
If you would show me a specific pair of scissors, I would answer it. That would be my response, and that's why we shouldn't discuss hypotheticals. There are millions of kinds of, not millions, there are plenty of kinds of scissors, and there are hundreds, limitless objects that could be considered weapons or that could
one of the fundamental principles of the requirement of specific criminal laws is to put people on notice
It's
And-
to
as to what conduct is prohibited. And
it's to
you're
allow
working really hard to tell me that I'm not allowed to ask the questions that I want to ask about whether or not you, as a trained lawyer, can know what this statute means.
again my
And you're
position-
telling me I only know it when I see it.
My response is that there is Supreme Court of Kansas case law. I'm not telling you anything. I'm telling you what your case law says. Your case law says that when somebody is challenging a statute as unconstitutionally vague, they cannot challenge it based on hypotheticals. It has to be confined to the facts of their case. So if this defendant had had a pair of scissors, I would be prepared to come before you
And
today.
the facts of this case include not only the knife that he possessed, but the information that he was told about that knife by his parole officer.
Yes.
And that's why I think the issues are pretty closely intertwined.
Well, I guess I don't see the two issues being all that closely related. Whether the specific object is a knife, I think, is separate and apart from what his parole officer had told him. And again, I think that as to my specific answer, it just illustrates that there are so many different hypotheticals.
Why do you think this mistake of law happened in the first place?
If you want my honest answer, I think that this is an after-the-fact attempt on the defendant's part to excuse the fact that he was found with a knife. He also tried to throw out there that it was something that he needed for work. I think that this was something that he was grasping at straws and trying to present.
Maybe I misunderstand. I understood that he was, in fact, told that this knife would be permissible.
So after he possessed the knife is when he got he contacted his parole officer after having committed the crime.
But you're not contesting the fact that he was actually told what the parole officer said. And
Well,
what's in the-
I'm
and
trying
what's
to
in the
answer that
handbook.
because I think it's very important. I am not disputing that after he committed the crime, he got a letter from the parole officer specifically telling him that this knife is all right. That is absolutely correct. Our response to that is what he was told after the fact is irrelevant. He also definitely got the handbook.
Okay, but my question specifically is, why do you think the handbook says what it says?
Oh, I think the handbook, and I think the Court of Appeals was probably right on this. I think the handbook was probably going off an old version of the statute defining criminal possession of a firearm.
As opposed to trying to clarify what the writer of the handbook considered to be a vague statute.
No, I think the panel is right about that. In my conversations with our trial attorneys also, I think that they're also under the impression that this was simply the handbook had not been updated at the point of this guy's trial and post-release. And so we do have an argument, and I pointed this out both in the supplemental brief and in the original brief. There's no dispute that he got the handbook. He never made a proffer specifically that he read this provision, let alone that he relied on this provision, on this particular portion of it. So to the extent that for it to be a valid mistake of law defense, he not only, even if he can show you that this was in fact somebody authorized to interpret a statute, he also has to show you that he actually in fact relied upon that interpretation. And our position is that there was never a proffer here. This is obviously he's trying to get this evidence in. He has to proffer that it's relevant because he relied upon it. And I have reviewed the record multiple times in this case, and I see no indication that he ever proffered to the court that he read before he was arrested for this, that he read that provision, let alone that he relied upon it and was acting in reliance upon that interpretation.
Are you saying his testimony at the motion to reconsider doesn't count?
I think he testified that somebody had maybe told him that.
He said, I went to state orientation just a couple of months before this. The whole place told me, everybody at that place told me, and they gave me that handbook stating, and they told me I could own that knife.
Right. So that says that they told him verbally, but the focus of this argument seems to be specifically about the handbook. So he did testify that yes, that he was given a handbook and that he was verbally told, but it requires a leap to say, okay, he got the handbook, so he must have therefore A, read that handbook word for word, and B, then that reading of the handbook caused him to rely upon that subsection, and that's why he possessed this knife.
Isn't what he's saying he was told consistent with what's in the handbook?
I don't interpret it that way. To me, he's saying.
How's it different?
I think he said, I was given a handbook, and I was told by people that this knife was something that I could possess.
Wasn't the knife under the length specified in the handbook?
Yes, it was. And
So, according to the handbook, he could have that knife, right?
according to the handbook that we don't know if he read or relied upon.
Right, but if he was told something, if they told him he could have that knife, that would be consistent with what was in the handbook, right?
Yes, it's consistent with it. Yes.
Okay.
Yes, yeah. And again, I don't dispute what you're saying. I'm just pointing out that much of what the questioning here has come down to is the handbook itself. And I just want to differentiate because we've got three separate things. We've got the handbook, which he was given, but we don't know if he actually read. We've got the statements, which, as Your Honor points out, he did specifically proffer that he was told these things. And then we have this after-the-fact letter, which, while we don't dispute he got, we have no idea how that could be relevant because it was something that occurred after he had already committed the act that he was charged with. So I think it is important to kind of divide these things up, and I think the panel's opinion sometimes is somewhat loose in its language because they're talking about letters and handbook and verbal statements, and they're just kind of lumping them all together.
I agree with that, and I know you're over time, and I don't want to push us too far, but it doesn't seem as complicated as your argument implies. It seems to me it's enough that the parole officer said it, and what she said is consistent with the handbook, which gets back to my original question. Really, all she's doing is parroting the handbook, which can then become the official interpretation that we're trying to get to. I don't think you have to show that he read the thing and relied on it. To me, it's enough that there's one consistent message coming from the same organization.
But that
which has this responsibility.
Right, and that would still then come down to whether that agency and or its employees are in fact authorized to do this.
I don't disagree.
Okay, yeah, I would agree with that. I mean, to the extent that the parole officer herself told him this information before he possessed the knife, our position would be that even in that situation, even if he did hear that information and that caused him to think that he could possess the knife. And we recognize, obviously, there is a degree to which, even as a prosecutor, you can sympathize with somebody to the extent that they're saying, hey, this person told me that. But the law itself, as this court has indicated, and I think even more so in recent days, you have to interpret statutes by what they actually say. And while the statute, I think the biggest mistake, in my opinion, that the Court of Appeals made here is that they look at the statute that defines the purpose of the DOC, and they say, well, that purpose includes educating people on post-release for re-entry into society. And they say, in order to do that, the DOC must, I believe is their exact word, they must be authorized to interpret statutes. To me, in making that leap, the Court of Appeals was legislating from the bench. The statute itself does not say statutory interpretation. So while the panel might think that educate should include interpreting statutes, that's not what the language of the statute itself says. And so our position is quite simply that while there might be a degree of sympathy for the defendant in this situation, that under the law itself, he was not entitled to rely on this because this was not an official interpretation of a statute. And Your Honor, I certainly didn't mean to suggest that you weren't entitled to ask me any questions that you want. I simply, again, just citing back this court's own law with respect to whether that type of challenge from the defendant is properly raised, and as by way of trying to explain why I was having difficulty with a specific hypothetical there. If there are any further questions, obviously I'd be happy to address them.
Thank you.
Thank you.
May it please the court, Mr. Harris appears through counsel Casper Shire, Kansas Appellate Defender Office. This is not a case that rests on hypotheticals. In this case, Mr. Harris was advised by the KDOC handbook and by his parole officer that he could have, quote, an ordinary pocket knife with a blade no longer than 4 inches, and that such a knife, quote, is not considered by law to be a dangerous knife or a dangerous or deadly weapon or instrument. In short, the Secretary of Corrections interpreted the residual clause of KSA 216304 not to prohibit possession of the short-bladed utility type of knife that Mr. Harris had. His parole officer told him that too. Mr. Harris relied on that interpretation. He stressed to the court numerous times over the life of this case that he was not a lawyer, that he was not qualified to interpret statutes, and that he was relying on the interpretation of somebody that he thought he could trust in his parole officer. Unfortunately, the law enforcement officers in this case took a very different view of the residual clause of KSA 216304 and determined that his folding knife was in fact a knife for statutory purposes. And this is exactly the type of unpredictable ad hoc law enforcement that the Due Process Clause of the Fifth Amendment was designed to protect us from. The problem with this statute, to put it in terms of Johnson v. United States, is that it does not put ordinary people on notice of what is lawful and what is not, and it invites arbitrary enforcement of the law. For those reasons, we are asking this court today to strike down the residual clause of KSA 216304 as unconstitutionally vague. I'd like to turn to the Court of Appeals analysis on the vagueness issue. The Court of Appeals essentially looked at the residual clause of the statute, in other words, the definition of knife as a dagger, dirk, switchblade, stiletto, straight-edge razor, or any other dangerous or deadly cutting instrument of like character, and really focused in on the language dangerous or deadly cutting instrument. And the Court of Appeals concluded that because an ordinary person could determine what is and what is not a dangerous or deadly cutting instrument, the statute was not vague. But in the wake of Johnson v. United States, the United States Supreme Court case that looked at the residual clause in the Armed Career Criminal Act and determined that particular residual clause was unconstitutionally vague, I don't think that's the analysis that's required. Specifically, the residual clause does not criminalize the possession of any dangerous or deadly cutting instrument. It only criminalizes the possession of a dangerous or deadly cutting instrument if it is of like character to one of the items in the preceding list: a dagger, dirk, switchblade, stiletto, or straight-edge razor.
Excuse me. Are you familiar with the last antecedent rule? You know, the doctrine, you know, as far as if you apply the last antecedent, you're as for example, you're talking about like character. If you apply the rule, it would only apply to a deadly cutting instrument, okay? And it wouldn't apply to any of the remote factors that they're talking about as far as a definition. Would you agree?
I think if I understand the question right, then yes.
Okay, I mean, I can cite to you the rule. The last antecedent doctrine says relative or modifying phrases are to be applied to words immediately preceding them and are not to be construed or extending to remote phrases, okay?
Okay.
Now, and when you look at this particular definition, and the legislature used means, okay? That word means is very important because generally they use means to set out a stipulative definition, you know, a definition that is restricted and that is all inclusive. Would you agree? Let me give you an example, okay? Let's say that we're defining what a vehicle is. A vehicle means an automobile, bus, trolley, tram, or electrical driven car. If we had that definition, that means, okay, then, you know, a horse-drawn carriage would not fit within that definition.
I agree, Your Honor.
Okay. You said that the statute is so vague that it could include a butter knife. Is that correct? You made that assertion? Plastic? You used the word plastic?
Yes,
Butter
that
knife.
was the hypothetical used in the briefing, Your Honor.
Okay. Now, could you include a plastic butter knife within these terms which this stipulative definition sets out?
I'll agree that a plastic butter knife might not have been the best example, Your Honor, but I think the problem with the residual clause is that it does invite every person reading the statute to bring their yardstick to measure their own yardstick to measure what is and what is not of like character to a dagger, dirk, switchblade, stiletto, or straight edge razor. And I think that's exactly what we see happening in this case. Department of Corrections looked at the statute and made two determinations as I see it. One, that short-bladed utility knives are not of like character to a dagger, dirk, switchblade, stiletto, or straight edge razor because they're not weapons in the same sense that a dagger, dirk, switchblade, etc. would be. The other exception in the DOC handbook is for blades used for work purposes. So in other words, if you're using a machete to cut brush, or if you are washing kitchen knives in a restaurant, those items that you're handling and in possession of are not weapons for the purpose of the statute, knives for the purpose of the statute, because they don't have the same character of a dagger, dirk, switchblade, stiletto, or straight edge razor, and that they're not really weapons.
But doesn't this definition really sets out what actually fits? Especially, I mean, when it tells you, for example, a deadly cutting instrument. I mean, just like what you agreed to, your plastic knives wouldn't fit in that. I mean, if I was looking at that, if I had a plastic a butter knife, I would know that this one be included. Wouldn't you agree?
I'm not sure that I necessarily do, Your Honor, because I think it all depends on what yardstick you bring to determine what is dangerous or deadly cutting instrument. And the point I was trying to make is that law enforcement and also the state in this case are bringing a very different yardstick than Department of Corrections was. They're saying anything that's sharp and cuts and can do damage is a knife for statutory purposes. The point I'm trying to make here is that reasonable minds are differing about how we even determine what a dangerous or deadly cutting instrument is. And I think very few reasonable minds are going to come to the conclusion that a plastic butter knife is a dangerous or deadly cutting instrument, but there are certainly situations where it could be used that way. And frankly, the facts of this case are probably better than the butter knife hypothetical to show the problems inherent in figuring out what in the world this statute means. Because we have one agency on one hand saying that's excluded from the definition of a knife, and we have another agency on the other hand saying, well, this is something we're going to prosecute you for or convict you for. That itself shows the vagueness of the statute, Your Honor. I'd also like to talk a little bit about the evidentiary issues. And here we are, of course, asking this court to affirm the Court of Appeals. We believe that the Court of Appeals was absolutely right in determining that the advice from the manual and the advice that Mr. Harris got from his parole officer is exactly the type of executive branch interpretation of the law that this court envisioned in VFW Post 3277. Opinions of the Attorney General and of the heads of other enforcement agencies. In fact, if the facts of this case don't give rise to a mistake of law defense, it's hard for me to imagine facts that would. Mr. Harris was explicitly told that he could possess exactly the type of knife that he had.
What would be your argument if there had been no handbook and only the parole officer giving the information? Would the same result occur, or is the handbook a necessary part of your position?
I think the handbook certainly strengthens the position a great deal, but the Court of Appeals ruled that the parole officer as well was a public official for the purposes of the statute, authorized to interpret the statute. So I think even the parole officer's opinion standing on its own would have been enough to merit the defense. It's certainly a stronger defense with the handbook to back it up, though, Your Honor. The gist of the Court of Appeals opinion on this issue, which I think was absolutely correct, is that enforcement agencies like the Department of Corrections have to interpret statutes to do their job of enforcing the law. And here their job is to educate and to rehabilitate individuals on parole. That is their job. And part of that job is making sure those individuals know what the law is so that they don't violate it. Without the ability to interpret the statute, there's no way they can do that. And individuals in Mr. Harris' position are justified in relying on that interpretation. Responding to the state's argument that statutory interpretation isn't a listed duty of the Department of Corrections in that statute, I'm not sure that statutory interpretation is a listed duty of the Attorney General, for that matter. Nevertheless, it's something that we know they're going to do because they're an agency head. The statute could have limited mistake of law defenses to opinions of the Attorney General. It chose not to. It said instead heads of agencies and public officials. These are precisely the types of interpretations that give rise to a mistake of law defense. The bottom line here is that Mr. Harris shouldn't be punished for doing the right thing. People in his position, individuals on parole and probation, are routinely advised that when they aren't sure about the law, they should consult their parole officer or their probation officer, and that they should take that advice, which is exactly what he did. He was then prevented from putting on a defense based on his reliance on that advice. For all of those reasons, we are asking this court today to affirm the Court of Appeals on the evidentiary issue, to reverse the Court of Appeals on the vagueness challenge, to strike down the residual clause of KSA 216304 as unconstitutionally vague, and to vacate Mr. Harris' conviction. And unless this court has further questions, that concludes my presentation.
Thank you, counsel.
May it please the court, I so seldom have rebuttal time that I feel like I should probably take advantage of it, but I honestly don't think that I have a whole lot of new points to make. I guess just to sum up our position, in case I didn't make it clear, we would just ask this court to consider that in order to rule in the defendant's favor on the evidentiary issue, you would have to not only find that the handbook and or the parole officer were authorized to interpret this statute, but that you would then also have to find that in this particular case, that the defendant did in fact rely upon that interpretation. Our position with respect to the first prong of that is that this is not, that statutory interpretation is not a power that the parole officer or the DOC that the handbook have. And second of all, we argue that this was not a situation where the defendant made a sufficient proffer to show that he did in fact rely on the handbook itself.
Do we at this stage really have to determine that he relied on it, or is that a jury question?
Well, he would have to, I think in order to get the defense, in order for it to be a valid defense, the test does require a showing that he relied upon it. And so I think as part of his proffer in a situation like this, where the court was asked to rule on the admissibility of it beforehand, then I would think that the defendant, just like any other proffer you have to make, you have to show all of the reasons why a particular piece of evidence would be relevant. And in this situation, it can't be relevant unless he's relying upon it. So I think that in order to get to that step, yes, it would be up to the court to determine that in the first place. I think that's all part of the decision that the district court would have to make in the first instance, and then on appeal that the Court of Appeals and this court would have to make. Otherwise, it's just more of a, I don't know if it would quite reach the level of an advisory opinion to just say hypothetically whether somebody could rely upon it, but I do think that it is the defendant's burden to make a proffer showing that he in fact did rely upon it based on what the mistake of law defense requires. If there are no further questions, our position would be that the Court of Appeals was correct in finding that the statute is not unconstitutionally vague, but we do feel that the panel erred in determining that the district court should have allowed the mistake of law defense.
Thank you, Counsel.
Thank you.
We will take this matter under advisement.